Welcome to So Ordered, where we create audio readings of SCOTUS decisions to make them more accessible to the public. At the time of creating this podcast, the Supreme Court of the United States does not release audio of the court's decisions. Our mission is to make it so the public can be better informed on decisions of the court by using AI to generate audio of written opinions. The case before us today is Trump v. Barbara, docket number 25-3065, decided June 30th, 2026. Before reading the opinion itself, here is a brief summary of the case and the questions presented. On January 20th, 2025, President Trump issued an executive order providing that children born in the United States to parents who are unlawfully or temporarily present here are not subject to the jurisdiction of the United States, and therefore do not qualify for citizenship under the 14th Amendment or the Immigration and Nationality Act. Several parents filed suit, some in the name of their children, arguing that the order violates both the 14th Amendment and that act. The district court agreed, provisionally certified a nationwide class of children who would be denied citizenship by the order, and preliminarily enjoined its enforcement. This court granted certiorari before judgment. The question presented was whether the executive order complies on its face with the Citizenship Clause and with Section 1401, subsection A, of Title 8 of the United States Code, which codifies that clause. The court held children born in the United States to parents who are unlawfully or temporarily present are subject to the jurisdiction of the United States and are citizens at birth under the Citizenship Clause of the 14th Amendment. Chief Justice Roberts delivered the opinion of the court, in which Justices Sotomayor, Kagan, Barrett, and Jackson joined. Justice Jackson filed a concurring opinion, in which Justice Sotomayor joined as to the introduction and Part 1. Justice Kavanaugh filed an opinion concurring in the judgment and dissenting in part. Justice Thomas filed a dissenting opinion, in which Justice Gorsuch joined. Justice Alito and Justice Gorsuch each filed dissenting opinions. As a reminder, the audio is an AI-generated reading of a published opinion of the Supreme Court of the United States. The voice you will hear has been synthesized to loosely resemble that of the justice that wrote the opinion. All tone, inflection, pacing, and emphasis are produced by the AI model and should not be attributed to any justice. The text itself has been lightly adapted to aid in the creation of the spoken delivery. This is a project to attempt to make court decisions more accessible to the public, and any substantive changes during the reading are completely unintentional. Please visit www.supremecourt.gov to read the opinion published by the court. You can find a link directly to the opinion in this episode's description. As the audio is AI generated, you may hear some audio glitches, including odd pronunciation, noticeable pauses, or repeated words. We do our best to remove these and hope they do not impact your listening experience. To leave us feedback on the show or to learn more about the podcast, please visit so-ordered.org. The following is the opinion of the court in Trump v. Barbara.
At issue in this case is whether the Constitution guarantees citizenship to children born of parents unlawfully or temporarily present in the United States. The 14th Amendment provides, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. On January 20th, 2025, President Trump issued Executive Order Number 14,160, titled Protecting the Meaning and Value of American Citizenship. The order provides that children born of persons unlawfully or temporarily present in the United States are not subject to the jurisdiction of the United States and thus do not qualify for citizenship under the 14th Amendment or the Immigration and Nationality Act, INA, which uses the same language. Several parents filed suit, some on their own behalf, others on behalf of, and in the name of their children. They argued that the executive order violates the 14th Amendment and the INA. The district court agreed. It provisionally certified a nationwide class of children who would be denied citizenship by the order, and preliminarily enjoined the order's enforcement. We granted cert before judgment. To understand the Citizenship Clause of the 14th Amendment, it is first necessary to understand the context in which it arose, and the opinion of this court, Dred Scott v. Sanford, that it rejected. The story of citizenship in the United States begins with the English common law. Before the Revolution, the American colonists, like all in the British Empire, were considered subjects of the sovereign. That arose not from royal fiat, but from what the common law conceived as the relationship between the sovereign and the people. The king owes those born within the dominions a duty of protection, and in return for that protection, those born within the dominions owe the king a duty of allegiance. Children born with that allegiance were natural-born subjects. Because the sovereign's power, and thus his duty, was limited in various respects, so too was the scope of this rule. He could not demand allegiance from, for he could not protect, those born in lands that he did not control. Among that group were the people born in the king's lost dominions, France, Aquitaine, Normandy, over which he claimed an absolute right, but had no actual power to rule. The same held true even in discrete areas within his kingdom that were temporarily outside his control. If enemies were to possess a castle or fort, their children would not be born under the king's legiance. And the same held true for ambassadors and their families, who were considered, by a fiction of extraterritoriality, to remain on foreign soil and thus under the legiance of their home country. In all other respects, however, the sovereign's power and his claim to the people's allegiance was complete. A foreign mother could enter the British Isles, give birth, and leave with her child the very next day, and that child would remain a British subject. Why? Because the child owed an implied allegiance to the sovereign who protected him at his birth, no matter how momentary and uncertain his presence in the king's realms. The same rule applied to children born in the realm of parents subject to expulsion. For example, children of gypsies, today called Romani or Roma people, born in the realm were natural-born subjects, notwithstanding that British law at the time directed the Roma people to avoid the realm under pain of imprisonment or even death. For those children, and all others born in Britain, the rule was the same. With protection came allegiance, and with allegiance came the status of a natural-born subject. This view crossed the Atlantic with the colonists and was adopted with little fanfare after the Revolution, as subjects of the sovereign became citizens of the states. This common law of citizenship, known as jus soli, or right of the soil, prevailed in each and all of the states after American independence and continued to emphasize reciprocal allegiance and protection. By the doctrine of natural allegiance, all who were born within the jurisdiction of a state were citizens. When the newly independent Americans confronted a novel situation, unknown to England, that of the quasi-sovereign Indian tribes, they turned to the principles of the common law. Did the tribes truly govern their people, or were their people wholly subsumed within the United States? Echoing Coke and Blackstone, Chancellor Kent answered with the common law. We have purchased the greater part of their lands, destroyed their hunting grounds, and gradually abridged their native independence, Kent acknowledged. Even so, he reasoned, the United States has never dealt with those people within our national limits as if they were extinguished sovereignties. They were instead dependent nations that maintained dominions of their own. Indians born under those dominions, he concluded, were not citizens or subjects of the United States, but members of alien and sovereign tribes. Others followed Kent's lead, all the while emphasizing that the very few exceptions to the sovereign's power were narrow indeed. In A Nation of Immigrants, An Asylum for Mankind, in Thomas Paine's words, jus soli's broad scope took on particular importance. The young republic attracted tens of thousands of émigrés from the Old World, Scotch, Irish, French, German, Welsh, and many more, some of whom hoped to stay only a short time, others of whom hoped never to leave. No matter their intentions, however, they could be assured that their children would be American citizens by birth alone. As Justice Story said, nothing is better settled. The very first American legal treatise agreed. See A System of the Laws of the State of Connecticut, 1795. Holding, children of aliens are citizens, for they owe a duty at birth to the government, under whose protection they came into existence, as did the antebellum era's foremost case on the topic. Lynch reiterated that the common law rule was the law of the land for the children of citizens and foreigners alike, including those foreigners here merely on a temporary sojourn. The promise of American citizenship, Lynch declared, extends to all persons born within the jurisdiction of the United States. The common law made no distinction on account of race or color, but the slave states did. As the Civil War approached, more and more Southern states sought to deny citizenship to Black Americans and openly rejected the common law to reach that result. It was not the place of a man's birth that made him a citizen, these states said, but the rights and privileges he may be entitled to enjoy. On that view, the prejudice of caste was unconquerable. Not even emancipation could confer citizenship, these states held, because free African Americans still suffered from social and civil degradation based on the taint of blood. With the common law abandoned, almost 500,000 free Black Americans in the South were left little more than strangers. In the odious decision of Dred Scott v. Sanford, this court imposed the Southern states' beliefs onto the nation. Chief Justice Taney, writing for the court, concluded that the words people of the United States and citizens had an unexpressed and atextual racial component, one that excluded all those descended from slaves. Even if Massachusetts or Connecticut chose to grant citizenship to the freedmen, they still could not participate in national affairs. They were born in the country, Chief Justice Taney acknowledged, and thus did owe allegiance to the government, the precise criteria for citizenship at common law. But they were not included, and were not intended to be included under the word citizens in the Constitution. For them, blood, not soil, was made the rule. Dred Scott was met with shock. Ever since the Declaration of Independence, Justice Curtis in a dissenting opinion wrote, "The received general doctrine has been, in conformity with the common law, that all free persons born within a state are citizens of the United States." Justice McLean in a dissenting opinion said much the same. Being born under our Constitution and laws, he explained, makes him a citizen. Northern newspapers condemned Dred Scott as a wicked and false judgment, an atrocious doctrine, a deliberate iniquity, and a willful perversion. The decision was, in Lincoln's famous words, an astonisher in legal history. Abolitionists swore to undo what the court had done. By birth, Frederick Douglass insisted, "We are American citizens. The Constitution knows all the human inhabitants of this country as the people," he explained, "no matter their color, class, or clime. All I ask of the American people is that they live up to the Constitution, adopt its principles, imbibe its spirit, and enforce its provisions. When this is done," Douglass predicted, "the glorious birthright of our common humanity will once again become the inheritance of all the inhabitants of this highly favored country." The court had overruled the common law, but the people, eventually, would overrule the court. It took more than a decade, and the addition of names such as Antietam, Gettysburg, and Chancellorsville to our national canon, but Douglass's vision of our common humanity would be fulfilled. The Reconstruction Congress did not start from scratch. In the midst of the Civil War, President Lincoln's Attorney General, Edward Bates, had issued a landmark opinion that sought to displace Dred Scott in favor of the common law. Citing the key authorities, among them Calvin's case and Kent's commentaries, Bates rejected the premise that citizenship is ever hereditary. "Every person born in the country," he wrote, "is, at the moment of birth, based on first impression, a citizen without any reference to race or color, or any other accidental circumstances." He acknowledged that there were some limits, hence based on first impression, not conclusive. But those exceptions were few, simply the small and admitted class of the natural born, composed of the children of foreign ministers and the like. To Bates, it was soil, not blood, that furnishes the rule, both of duty and of right. A year after General Lee's surrender at Appomattox, Congress sought to turn Bates's opinion into law. The result was the Civil Rights Act of 1866. The act declared that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby citizens of the United States. to the Reconstruction Congress, the act was simply assumed to invoke the common law rule, as Bates had in his ablest and most exhaustive opinion, and as the New York Court of Chancery had in the great case of Lynch v. Clark. Indeed, the bill's sponsor, Senator Lyman Trumbull, enthusiastically agreed with the bill's critics that it would make citizens of the children of Chinese and Gypsies born in this country. Even the infant child of a foreigner born in this land is a citizen under this bill, Trumbull declared. The specter of Dred Scott, however, loomed over Congress's efforts. Opponents of the act contended that Congress could not grant such expansive citizenship and set aside this court's precedent by statute alone. To quiet those concerns and to permanently enshrine the common law in the Constitution, Congress turned to the 14th Amendment. What the Civil Rights Act began, the 14th Amendment would finish. Like the Act, the 14th Amendment was intended to repudiate Dred Scott. This time, however, the goal was even grander, to put the great question of citizenship beyond the legislative power altogether, to settle the issue once and for all. The 14th Amendment achieved its aim. The Citizenship Clause mirrored the common law's criteria for citizenship. The clause starts, like the common law, with territory. A child must be born in the United States, not elsewhere, even to American parents. And the clause ends, again like the common law, with sovereign power. A child must be subject to the jurisdiction of the United States, unlike the families of foreign ministers. A child born on American soil and subject to American law was made an American citizen. Even the language of the clause is that of the common law. Lynch held that American citizenship extended to all persons born within the jurisdiction of the United States. So did Chancellor Kent, stating, "All persons born within the jurisdiction and allegiance of the United States are citizens." So did the first legal treatise on the rights of free black Americans. And so did the famed antebellum lawyer Horace Binney, stating children born within the limits and under the jurisdiction of the United States are citizens. Little wonder, then, that the Citizenship Clause's principal author would explain that its language was simply declaratory of the law of the land already. That law was clear. Any child who was born under the protection of the United States, that is, any child for whom no extraterritorial fiction applied, was made a citizen, for he owed a natural allegiance and thus obedience to the nation. The essential elements of citizenship are allegiance on the one side and protection on the other. Even putting the common law to one side, the Citizenship Clause's key phrase, subject to the jurisdiction, requires the same result. The word jurisdiction was hardly unknown to the drafters and ratifiers of the 14th Amendment. Congress chose to use an established legal term, and the clause must be interpreted in that light. In 1868, as today, jurisdiction, in the context of a sovereign, refers to the power of governing or legislating. To be subject to the jurisdiction of the United States, then, is to live under its dominion, a meaning reinforced by the clause's territorial focus on those born in the United States. The Citizenship Clause uses jurisdiction in its ordinary sense, referring to the power of the United States to govern those within its territory. The scope of that power was well settled in 1868, largely by the celebrated case of Schooner Exchange v. McFadden. Expounding on general principles, Chief Justice Marshall explained that jurisdiction referred to the full and complete power of a nation within its own territories. That absolute power was susceptible of no limitation, not imposed by the nation itself. All sovereigns, however, were understood to have impliedly waived their jurisdiction in certain peculiar circumstances, in essence, where exercising jurisdiction would degrade the dignity of foreign sovereigns. As in the context of jus soli, those peculiar circumstances arose most frequently in the case of foreign ministers. Every sovereign would hazard his own dignity, after all, if his officials abroad were made to owe temporary and local allegiance to a foreign prince. The limits of that exception were carefully defined. Still within the United States power were the private individuals of a foreign nation who had spread themselves through our territory as business or caprice may direct. It would be obviously inconvenient and dangerous to society, and would subject the laws to continual infraction, Chief Justice Marshall explained. If such individuals or merchants were not amenable to the jurisdiction of the country, nor can the foreign sovereign have any motive for wishing such exemption, he continued, with respect to its sojourning subjects who were not employed by the sovereign or engaged in national pursuits. Just like jus soli, a sovereign's jurisdiction made no exception for those only temporarily present within the sovereign's territory. Instead, nearly everyone within the territorial boundaries of the United States was amenable to the nation's jurisdiction. The ordinary legal meaning of the text of the clause thus neatly captures the common law rule with its broad reach and narrow exceptions. The same groups included and excluded by jus soli were included and excluded by the conventional understanding of jurisdiction. Excluded by both were the children of foreign ministers and members of 19th century Indian tribes over whom the United States had ceded a part of its territorial jurisdiction to preserve its relationship with a foreign sovereign or quasi-sovereign. No such inter-sovereign concerns apply to children born of parents unlawfully or temporarily present in the United States. No foreign sovereign would have any motive for wishing them outside this nation's authority. Those children are thus subject to the jurisdiction of the United States. They satisfy both elements of the Citizenship Clause. They are born in the United States and subject to the jurisdiction thereof. Under the Constitution, they are citizens at birth. Our precedent, the seminal case of United States v. Wong Kim Ark, decided in 1898, confirms this rule. For nearly 2 decades after the 14th Amendment's ratification, the executive branch viewed the Citizenship Clause as simply an affirmance of the common law of England and of this country. Under that view, the status of citizenship was fixed by the place of nativity, irrespective of parentage, with the limited exception of the children of foreign ministers and of other persons who may be within our territory with rights of extraterritoriality. In 1872, for instance, Attorney General George Williams was called upon to determine the citizenship of a child born of Austrian parents only temporarily residing in New York City. Citing the Citizenship Clause and Bates's 1862 opinion, Williams explained that a person born in this country, though of alien parents who have never been naturalized, is, under our law, deemed a citizen of the United States by reason of the place of his birth. Thus the child is a native of this country, Williams concluded, and as such was originally clothed with American nationality. Secretary of State Hamilton Fish agreed. So did federal courts. Like the executive branch, they saw the clause as merely declaratory of the rule of the common law. As the era of Reconstruction faded, however, so too did the promise of birthright citizenship. Uncertainty came with the first Chinese Exclusion Act of 1882 and the election of President Cleveland, the first Democrat to hold the office since the Civil War. It was around this time that the State Department began to deny citizenship to those with dual or doubtful allegiance, and it was around this time that several scholars proposed a new theory of the clause, one based on international law. This new theory focused on the parent's status, not the child's. It was only if a child's parents were domiciled in the United States, they argued, that the child was internationally subject to the jurisdiction of the United States, as the Citizenship Clause, they said, required. These writers acknowledged that the common law took a different view and acknowledged that the language of the 14th Amendment is very broad. But they insisted that jus soli had been universally rejected by other nations and had not been made part of the Constitution. In Wong Kim Ark, this court rejected that view, concluding that no rule of international law had qualified the ancient rule of citizenship by birth within the Dominion. At issue was the citizenship of Wong Kim Ark, born in San Francisco to Chinese parents. In Wong's telling, the case was not close. There can be no just doubt, he argued, that the amendment was intended to be based upon the doctrine derived from the common law, that the character of a natural-born citizen is incidental to birth only. The government disagreed. It admitted that the opinions of the attorneys general, the decisions of the federal and state courts, and, up to 1885, the rulings of the State Department all concurred in the view that birth in the United States conferred citizenship based on the common law doctrine of allegiance and the authority of the decision of Chancellor Sanford in Lynch v. Clark. But the executive no longer endorsed that view. The common law doctrine of England, it argued, had in fact never been the doctrine of the United States and was not made the law by virtue of the Citizenship Clause. In an opinion by Justice Gray, the court rejected the government's position. Justice Gray explained that the 14th Amendment was merely declaratory of the fundamental rule of citizenship by birth that prevailed at common law. That same rule, he wrote, was in force in all the English colonies and continued to prevail under the Constitution, and its contours were clear. It excluded those recognized as exempt from the jurisdiction of this country, the children of ambassadors and other representatives of foreign sovereigns, as well as those born in the alien nations of Indian tribes. All others were citizens at birth, whether born to permanent residents or temporary visitors. Indeed, Justice Gray noted, no one had even contested this conclusion for more than 50 years after the adoption of the Constitution, until the matter was elaborately argued before the New York Court of Chancery in Lynch v. Clark. And there the question was decided upon full consideration by Vice Chancellor Sanford in favor of their citizenship. The same doctrine was repeatedly affirmed in the executive departments, Justice Gray wrote, not to mention by Kent and Binney, each of whom affirmed that the child of an alien, if born in the country, is as much a citizen as the natural-born child of a citizen. In adopting the common law, Justice Gray explained, the Citizenship Clause adopted this same rule. Justice Gray then turned to Schooner Exchange to confirm what the common law made clear. The words, subject to the jurisdiction thereof, he wrote, must be presumed to have been understood and intended by the Congress in the same sense in which the like words had been used by Chief Justice Marshall in the well-known case of the Exchange. On that understanding, aliens who traveled to the United States for business or pleasure received no exemption from the jurisdiction of the country. To the contrary, they were subject to that jurisdiction for as long as they remained here, and any children born to them were American citizens under the 14th Amendment. What the court held in Wong Kim Ark was simple. The Citizenship Clause incorporated the common law and granted citizenship to nearly all children born in the United States. Not surprisingly, then, in the 128 years since, we have repeatedly understood the rule of Wong Kim Ark to guarantee citizenship to all children born in the United States and subject to its power. We see no reason to depart from that view today. The government and the principal dissent share many of our premises. They agree that the Citizenship Clause was intended to incorporate the background principles of the common law. They agree that, under the common law, citizenship turns on allegiance. And they agree that Dred Scott departed from that traditional, allegiance-based view of citizenship, a departure that Congress repudiated in the clause. Where the government and the principal dissent error is with their definition of allegiance. They concede that Calvin's case and Blackstone state the rule that prevailed before the Declaration of Independence, that a natural allegiance arises for all children who are born here under the protection of the sovereign. Yet according to the government and the principal dissent, the United States conception of allegiance, at some unspecified point in time, broke from Great Britain's. The government has variously dated this change to the late 18th century, the early 19th century, and the Reconstruction era. The principal dissent declines to offer a date. Natural allegiance, they contend, was no longer sufficient for citizenship. Some greater quantum of allegiance was required. How much? The government offers a smorgasbord of formulations: primary allegiance, sufficient allegiance, full allegiance, requisite allegiance. The principal dissent, for its part, seems to have settled on primary allegiance. What all these formulations supposedly share is that they turn on domicile. the place of one's permanent home. At some point before the ratification of the 14th Amendment, the argument goes, it became deeply rooted in this country that domicile is the key concept that creates allegiance. The trouble is that there is scant evidence for this dramatically revisionist view. Certainly no one said that such a change had occurred. Indeed, even as the antebellum Americans hotly debated whether the Declaration of Independence had abrogated one aspect of the British common law, that natural allegiance was indefeasible, no matter a person's desire to expatriate, all agreed that such allegiance was owed in the first place. Perpetual allegiance does not stand upon the same reason or principle as the common law doctrine of allegiance by birth. Noting unsettled question of whether an American citizen can divest himself absolutely of his citizenship, but simply presuming that any person born within the United States was a natural-born citizen. The only evidence the government and the principal dissent can muster to show that some alternative primary conception of allegiance displaced the common law is a funeral oration for President Lincoln. Ahistorical modifiers aside, the government and the dissent identify no source that defined allegiance at birth as being based on domicile in the period from 1776 to 1868. Sources from that period instead defined allegiance by birth, just as the British did, as the tie or duty owed by one who is born within the dominions and under the protection of a particular sovereign. Of course, some wished to change the rule. But even those who wished to limit jus soli did not deny that children born of temporary visitors owed natural allegiance to the United States. They instead thought that domicile might serve as a reasonable qualification to the common law rule, namely, that citizenship derives solely from the natural allegiance owed to the government of the territory of a man's birth. The principal dissent, but not the government, at times seems to directly equate domicile and national citizenship. That is wrong. It is, in fact, a general axiom of international law that there may be domicile where there is no nationality, and nationality where there is no domicile. After all, one who establishes a domicile in a new country does not automatically become a citizen thereof. He has to be naturalized, nor does he automatically lose his prior citizenship. He has to expatriate. Thus, the principal dissent ultimately acknowledges that domicile alone was insufficient to make someone formally a citizen. Of course, domicile was relevant to naturalization and expatriation, but that by no means suggests it was a prerequisite to national citizenship at birth. The principal dissent's reliance on cases concerning changes to a person's state citizenship is thus misplaced, and the government's remaining support for the idea that a domicile qualification to birthright citizenship was widely accepted in the United States before the Civil War consists of a single state court case about citizenship in the Republic of Texas, a proposed but never adopted model code for the state of New York, and another treatise that discussed the subject only in terms of the principles of natural reason, which it expressly distinguished from the common law. The congressional debates over the Civil Rights Act of 1866 and the 14th Amendment confirm our view. The principal dissent and the government lean heavily on a handful of ambiguous floor statements referencing temporary sojourners and foreigners. See, for example, the 39th Congress, Representative Wilson stating, "It may be that children born on our soil to temporary sojourners do not fall within the Act's scope." Also, Senator Howard stating, "The citizenship clause would not, of course, include persons born in the United States who are foreigners, aliens who belong to the families of ambassadors or foreign ministers." Far more frequent and explicit, however, were statements embracing the common law, and the debates make clear that no member of Congress seriously grappled with a domicile-based carve-out to the fixed, certain, and intelligible rule of the common law. For a Congress intent on putting the question of citizenship once and forever to rest, a domicile-based qualification would have introduced significant uncertainty. Unlike the easy-to-apply common law, it would be difficult, if not impossible, to lay down any general rule of domicile-based citizenship, as domicile often depends upon the circumstances of each case, the combinations of which are infinite. If Congress intended to hinge citizenship on each individual's domicile, a question that is sometimes a matter of great difficulty to decide, it is reasonable to expect there would have been at least some discussion of the topic. Yet the word domicile appears just twice in the discussion of the relevant provision of the Civil Rights Act, and it appears in only one speech from the Citizenship Clause debates, as part of an explanation of why state citizenship is distinct from national citizenship under the Constitution. Perhaps recognizing the absence of ratification-era support for a domicile-based rule of national citizenship, the government and principal dissent both emphasize sources from after the ratification of the 14th Amendment. They turn to the same international law treatises that underpinned the government's attempts to limit birthright citizenship in the 1880s. This fundamentally revisionist scholarship and the post-1884 executive branch actions that relied upon it do not put in doubt the understanding of the Citizenship Clause at the time of and after its ratification. As Senator Trumbull explained in 1871, the Citizenship Clause recognized that every person born within the jurisdiction of the nation was a citizen of the United States, as had been true under the common law of this country as well as of England. In any case, post-enactment history cannot override the text. If Congress intended to limit American citizenship to the children of those domiciled in the United States, nothing in the succinct language of the Citizenship Clause conveyed that design. Words appearing frequently in the executive order, mother, father, lawful, temporary, are absent from the clause. For a simple reason, they did not matter. And while the clause does ensure state citizenship attaches for United States citizens in the state wherein they reside, Amendment 14, Section 1, the explicit invocation of residence for state citizenship only highlights its absence from the criteria for United States citizenship. In the Slaughterhouse Cases, 1873, it was held a person can be a citizen of the United States without being a citizen of a state. When the principal dissent does grapple with the operative legal text subject to the jurisdiction of the United States, it has little to say. It argues only that a person is subject to the jurisdiction of the government of his domicile. But that is not the question. The question is whether a person is subject to the jurisdiction of the government of the country in which he is physically present, even if he is only there temporarily. He is, unless he falls under one of the familiar exceptions, such as for ambassadors. For the reasons given by Chief Justice Marshall in Schooner Exchange, the United States exercises full and complete power, its absolute and complete jurisdiction, over temporary visitors. To avoid these problems, the principal dissent spends much of its time on the text of the Civil Rights Act. Justice Alito does the same, albeit in service of a different result. The Civil Rights Act made citizens of all persons born in the United States and not subject to any foreign power. The principal dissent contends that a person is not subject to any foreign power if and only if he is domiciled in the United States, for it is then, and only then, that his home nation is forbidden from regulating his conduct. Justice Alito contends that a person is not subject to any foreign power if, and only if, no other country would automatically make him a national, whether he is domiciled here or not. Neither theory works. As to the principal dissent, it is simply not true that domicile in a new nation severs one's ties to the old one. Nations generally assert a claim to regulate the rights, duties, obligations, and acts of their own citizens wherever they may be domiciled. If the test truly is whether a person is amenable to the laws of two governments at once, then it is a test that every child born to a foreign parent fails, a result that even the principal dissent cannot stomach. Justice Alito seems to recognize this bind, so he would create an ad hoc exception for those whose parents have done everything within their power to become Americans. He does not explain how that exception can be squared with his view of the text, which, to repeat, is that anyone automatically made a national of his parents' native country was not entitled to citizenship under the Civil Rights Act. In our estimation, the Act raises more questions than answers, and was replaced by the 14th Amendment, which better expresses the views of the Reconstruction Congress anyway. This court said as much in Wong Kim Ark. For the dissents and the government, Wong Kim Ark is essentially irrelevant. They attempt to narrow that precedent by noting that the court's opinion repeatedly referred to the domicile of Wong's parents. That is true, but the reasoning underlying the holding of Wong Kim Ark cannot be squared with a domicile requirement of the sort the government envisions. As we have already explained, the court exhaustively canvassed the text and history of the Citizenship Clause. It traced an unbroken line from the English common law into the founding and antebellum eras, and through the debates to the clause's ratification. Yet at no point did the court identify any evidence in the historical record that the ratifiers of the 14th Amendment thought themselves to be imposing a domicile limitation. In the end, it is the dissent in Wong Kim Ark that makes the strongest case for a domicile-based theory of American citizenship. There, Chief Justice Fuller resisted the application of the English common law rule because it recognized no exception in the instance of birth during the mere temporary or accidental sojourn of the parents. He admitted that, in England, the question of domicile is entirely distinct from that of allegiance because the one relates to the civil and the other to the political status. But he believed that a different view as to the effect of permanent abode on nationality had been expressed in this country. Under this different view, the 14th Amendment prevented the acquisition of citizenship by the children of aliens whose parents owed local and temporary allegiance, merely remaining subject to a foreign power. The government and today's dissenters agree. But this view commanded only a dissent in 1898, and neither time nor circumstance has changed the fact that it is not the law. Again and again the dissents cast the common law as feudal, medieval, a remnant of the darkness of the Middle Ages. That was not the view of the Reconstruction Congress. Where the dissents see feudalism, the framers of the 14th Amendment saw emancipation. By the time of the Glorious Revolution in 1688, in fact, the tie created by birth was less a duty than a right, the foundation of the ancient liberties of freeborn subjects. That is why Blackstone described the privileges owed to the natural born. That is why the colonists demanded the rights of Englishmen more than 250 years ago. And that is why abolitionists lauded the ancient and universal rule of citizenship by birth alone as an ordinance of heaven. Citizenship, then and now, was the right to have rights, to freely participate in our political community. The framers of the 14th Amendment extended that promise to every freeborn person in this land. We keep that promise today. The judgment of the District Court for the District of New Hampshire is affirmed. It is so ordered.